Okay, so welcome to our subject, Special Crime Investigations with Legal Medicine. So we will discuss the whole coverage for the first exams. And then I would like to remind you in advance that there will be another set of SIM will be uh, downloaded to the LMS, no? Always open your LMS so that you will be updated with our subjects. Okay. So first, we will discuss first the brief history of the criminal investigations. Okay. So the origin of America's systems of criminal investigations can trace back to the towns and cities of England throughout the 18th and 19th centuries. The ensuing crime wave forced law enforcement officials to take extreme measures. As a result of thief catchers were recruited from the shop of the street to assess the law enforcement officials and tracing criminals. So the history of the criminal investigation, it was started aeons ago during the time of Henry Fielding, Robert Fields, so on and so forth. Okay? Now, at that time, there were two types of thief catchers. Pag minutag thief catchers, katuning nagadakop sa mga kawatan, no? So, first is we have the Harlings. Harlings, they are the first group of people who are in charge by the government to run after the criminals. The Harlings' motivations were just for the benefit of monetary considerations or mercenary in nature. So, ang kailangan sa Harlings, so anong gitawag sila Harlings kay, muhatag sila informations or sila mismo ang mudakop sa suspected criminals provided nga bayaran sila og kwarta. Meaning, their services is not for free, no? So, kailangan na ikambyo na bayad. Then, the second one is the social climbers. Dili ni siya katong social climbers nga kanang kuan ha, kanang mga social lang diya nga bisag way kwarta, no? So, social climbers would connect their conspirators in order to move up the social ladder. So, ang ginabuhat aning social climbers is katong naibawaan nila nga kauban sa nangawat, mo to ilahang kwanon, mo to ilahang duulon, niya ko istoryahan lang, kuhaan lang informations. So pag makuha na lang information, ma-identify na gito kung kinsa tong mga kauban niya. So diya pa lang sila muliho. Okay? Unlike sa Harlings, once they will be given an assignment to identify the criminals and to arrest the criminals or to give the identification of the criminals to the authorities. So, kinala na sila bayad. Actually, nagyapoy bayad ni social climbers. Okay. Now, in England, the first police work only at night and were originally called as the Watch of London. So, they are the first investigator in London. They are called as the Watch of London. And later on, they are called as the Charles or the Old Charlie. So, magini sila ang unang police, no? Remember, the Watch of London or was changed into the Charles or the Old Charlies. They are the first police in London, no? Ang the Charles. Now, Bow Street Runners. So, Bow Street Runners, these are the form or the group which was founded by the Senior Chief Magistrate of London, no, in Bow Street Runners. That is referring to Henry Fielding. Okay. Now, criminal investigation in England, the Bow Street Runners during the 1750s. Due to rampant criminality, particularly the crime of burglary and robbery in Bow Street in London, Henry Fielding, as Senior Chief Magistrate Bow Street Court in London, personally contacted local residents, business owners, particularly the pawnbrokers, to personally coordinate with him and to help him due to the eagerness of Henry Fielding to stop, eradicate the crimes in Bow Street, London. Now, based on the experience ni Henry Fielding as a senior chief magistrate, nakita niya nga wala gyud bisag usa ka kriminal or kawatan nga nadagpan o napailan og kaso sa Bao Street Court. So because of that, daghang kay reklamo ang mga communities. So nipaso sa yung idea nga magtukod siya isa ka organizations, and that is known as the Bao Street Runners. Now the Bao Street Runners, primarily the first name of the Bao Street Runners is the Paris Constable, in which their work or the mode of the operation is similar to the night watchman duty. Okay, now let's continue. Fielding took seriously with his new responsibility as a crime fighter and create his own group as a new crime busters and applied a new crime fighting methods. One of the best such techniques is appointing of Paris Constable, adapted the night watchman duty. So meaning, wala sila duty sa adlaw, sa gabi ilang tanan, no? Kay kasagarang may tabo ang kawat, gabi man. These hunters quickly started carry out of criminal investigations, which is task and became a well-known and successful tip takers by means of their relations with London criminals underworld. Now take note, the first group which was founded by Henry Fielding, that is known as Paris Constable. But later, the Paris Constable was changed its name into Bao Street Runners. Balikan na to ha. Ang grupo nga gitukod ni Henry Fielding nga mao'y manakop o mo-identified sa criminal, dinatawag to siya og Paris Constable. Pero paglabay sa mga pipila ka mga panahon, ilang gialisdan ang pangalan. Gitawag na nila og Bao Street Runners. Now, this became a first well-known investigative body in England. Take note, the Paris Constable or the Bao Street Runners, that is the first well-known investigative body in England. So balikan na to, the first investigative body in England, that is the group of Henry Fielding, that is known as Bao Street Runners. But the first name of the Bao Street Runners, known as the Paris Constables of England. The Bao Street Runners are not paid. What they receive is an incentive through percentage to all funds resulting from successful prosecution of thieves. Now take note. So the Bao Street Runners, they never receive salary from the government. What they have received is the incentives. Dito say na imadakpan na kawatan. Ilang ipailan ng kaso, so mubayad man ang piyansa. So dito sa piyansa, na sila'y bahin, no? Na sila'y porsyento dito. Para saan ang nahitabo karon anang atuwa ka ng sa barangay tanod na manakop sila og katong walay face mask, no? So kutob sa ilang madakpan, multa na sa 500. So nana sila ginatawag nato og 60%. 60%, yes, 60% sa multa. Kung 500, 6 times 530, so nara sa 300. Ang 200 sa gobyerno, ang 300 sa ilaha. So that is similar to the work of the Paris Constable or Bao Street Runners. They never receive from the government, they never receive salary, but they receive incentive from those criminals who are arrested and charged in court. Okay? Now, the Bao Street Runners were forerunners of a trend policy or specialization within the police force. In England, the police worked only at night and were originally called as the Watch of London. Now, take note, the first police work at night in London, they are called as the Watch of London. So like ni siya nga grupo. Ang grupo gid ni Henry Fielding is katong the Paris Constable or the Bao Street Runners. Okay, so now let's continue. This one developed into the Old Charlies. Ang Watch of London, gi-change man itong pangalan, the Old Charlies, no? So the Old Charlies were paid by the residents. So ang Old Charlies would, they receive salaries directly from the community they serve, no? Atong sa komunidad mismo, let's say, Barangay 1. So, og naay nagapatrolya dito nga Old Charlies. So, katong Barangay 1 mo to ang nagabayad sa ilahang sweldo or trabaho sa Old Charlies. Okay. These Paris constables originated in London in 1253 and lasted until 1829. So the Paris constable or the Old Charlies was and their history in 1829, because in the year 1829, the first salaried and professional police was established, and that is created and founded by the known father of modern policing, in which we are referring to Robert Peel. So Robert Peel, when he was appointed as the chief of police, so he created the first salaried and professional police in London, and they called us the Bobbies of London or the Constable of London. So nahuman ang history sa Paris Constable o sa Bow Street Runners katong 1829, pero nagsugod sila katong 1253. Okay, now let's go to the London Metropolitan Police. Now take note, as we discussed earlier, that the London Metropolitan Police Force was created by Robert Peel way back in 1829, and they are called as the Bobbies of London or the Constable of London. Now, the London Metropolitan Police, the great watershed in British force or in British Police Force, development happened in 1829. So, di ba, nahuman ang history sa Constable, sa Paris Constable or sa Bow Street Runners, it was in 1829 because the Sir Robert Peel created the first salaried and professional police force in London, and that is called as the Bobbies of London or the Constable of London. Okay, now let's continue. With the beginning of the London Metropolitan Police Department, officers of the department were named Bobbies or Constable of London, after the department's founder, Home Secretary Sir Robert Peel. The new police were England's first paid full-time police force, which is consisting of about 1,000 uniformed officers at that time, no? And then, the Bobbies or constables, which is the origin of the British police, were compulsorily to meet rigid standards of professionalism. Minimum standards included minimum weight and height requirements, and standards of literacy and character. Skills in crime detections began to prosper during the 19th century, with the foundation of personal identification system by Alphonse Bertillon, which also appointed as the first director of the Criminal Identification Section of the Paris Police Department. So when Robert Peel created the first constable in London or the Bobbies of London, so that is also the time that they also create the London Crime Laboratory or the first personal identification system laboratory, in which Alphonse Bertillon was also appointed as the director of the Criminal Identification System of the Paris Police Department. Criminal investigations in America. Criminal investigation in America, as the frontline moved westward during the 19th century, criminals modeled serious problems in newly settled areas. Mining camps, towns seems to experience more violence compared to other areas. Law enforcement agencies, criminal courts, if present at all, made only minor progress in protecting the huge areas within the jurisdictions. Following the lead of London's police force, the first professional police forces were established in the United States at Boston in 1837. In New York, it was in 1844, and Philadelphia in 1854. By the 1870s, almost all major cities had a municipal police department in US. As England criminal investigations, public law enforcement was regarded as politically dangerous because it favored only those who could pay. So like, So kung nakaikabayad, so kaya nimong i-bribe ang pulis. So kung wala kay kabayad, apriso juga. But the rapid growth of cities produce violence crimes and vice activities that establish a breakdown of social order in communities. Growing incidents of crowd, violence between Protestants and Catholics immigrants, and Native Americans and abolitionists, and the pro-slavery groups were probably the most crucial catalysts for expanded police functions. Okay, so now let's go to the Pinkerton National Detective Agencies. So if you, as you have remembered, we going back with your subjects and the industrial security concepts. So we also discussed about the contributions of Pinkerton. Now, Pinkerton is the first national detective in US. So they are the first private detective agency which was commissioned by the FBI. When in fact, Pinkerton, he is a former member of the Chicago Police, no? Si Pinkerton. Okay. The Pinkerton National Detective Agencies or Pinkerton National Detective Agency founded in 1850 by Scottish immigrant Alan Pinkerton. The Pinkerton Agency was called on by communities to handle cases that the local enforcement officers were incapable to investigate due to incompetency or limited resources. So if you try to look at the work of Pinkerton, so atong una, ang mga komunidad, pag nanaytabong kawat, ikawatan sila, wala sila saling sa kapulisan. So instead nga, mudulog sila sa pulis para paimbestigahan o mahilang kung kisya nangawat, muadto sila dito sa detective agency ni Alan Pinkerton because believing that the group of Pinkerton have a capacity and a will skill in conducting criminal investigations compared to their local police. So murag nga lang natabwa. So kung ang may tabugan is kawat o nalang kawatan, murag na useless ang American police at that time. Kaya nga naman, dili man mo doon sila kung dili mo sila kay Alan Pinkerton, no? Magbayad sila dito. Now, Pinkerton offered the field of criminal investigations with several innovations. One of the best practice applied by Pinkerton is by way of devising the Rogues Gallery. So, ang isa sa natabang ni Pinkerton dito sa US Police is katong pag-devise sa ilang Rogues Gallery kung saan paghanay sa mga picture, sa mga katong nangadak pa nila itong una para pag-abot sa panahon nga na magreklamo, so mo na ito ilang abrihan, ipatanaw sa biktima kung mao ba ning dagwaya ang naghimuog krimen sa ilaha. No? That is one of the great contributions of Alan Pinkerton and the history of police America, in which Alan Pinkerton devising the method of the Rogues Gallery. Now, which was compilation of descriptions, methods of operating. So meaning, Rogues Gallery is a compilation of description, methods of operations, hiding places, and name of associates of known criminals. The Pinkerton National Detective Agency was the first organization of its type in the United States. In fact, its organizational structure was later adopted by the Federal Bureau of Investigations. So not only the American police adopt the system or the method made by Pinkerton, but also the FBI adopted the structural design made by Pinkerton. Now let's go to the very on the National Bureau of Investigation. So at present, the National Bureau of Investigations was reorganized into a modernizing National Bureau of Investigations by the virtue of Republic Act 10873 of June 23, 2016. So the present reorganization act and modernization of the National Bureau of Investigations by the virtue of Republic Act number 10867 of June 23, 2016 It is the policy of the state to promote and maintain an effective, modern, gender responsiveness, competent, and highly trained investigative body, functionally integrated and national and scope. Toward this end, the states shall formulate plans and programs to enhance and modernize National Bureau of Investigations with expanded structures, capability, and manpower responsive to the demands of the times. Reorganizations, modernizations, and expansions. The NBI is hereby reorganized and modernized to adequately meet the increasing demands of the community deserves of an expanded investigative and detective work. It shall implement in the modernization program gears toward the acquisitions of the state-of-the-art investigative and intelligence equipment and the establishment of forensic and scientific laboratories. The program shall include provisions for the training of its personnel in this regard. The present organizational structure of the NBI shall be reorganized into the Office of the Director, Office of the Deputy Director for all Administrations, Office of the Deputy Director for Operations, Offices of the Assistant Directors of the Investigation Services, Intelligence Services, Controller Services, Human Resource Management Services, Forensic and Scientific Research Services, Legal Services, and Information and Communication Technology Services. Each services shall be composed of the necessary divisions and sections. The NBI shall establish regional offices in every region, which to be headed by the regional director, and the district offices in every province to be headed by a head agent. Now, sa district offices sa NBI, ang head is known as the head agent. Field offices may also be established and maintained by the director as the need arises. So like for instance, kanang sa Davao del Sur, ang field offices sa NBI na dito sa Bansalan, sa Palengke. So kanang mga taga Davao del Sur, o taga Kidapawan, pwede na sila makuha ang NBI clearance dito na sa Bansalan. Okay, mas doon man. So dili na sila mga negli sa Davao. Okay, so now let's go to the NBI personnel complement shall be increased and the position upgraded as follows. So now let's go to the chart, no? So the old positions is Director 6. The new positions is Director, is known as NBI Director. So their salary grade is G30, there was no changes. Then for the deputy, for the Director 5 or Assistant Director, known as the Deputy Director. For Director 3 or Deputy Director, known as Assistant Director, from salary grade 27, it was increased into salary grade of 28. For Director 2 or for the Regional Director, from salary grade of 26, it becomes salary grade of 27. Sa bagong balaog katong RA, no, sa modernizations. Now, for the Director 1 or Assistant Regional Director, from salary grade of 25, it became salary grade of 26. Then, Investigation Agent 6, known as Head Agent katong sa district, so there was no changes of their salary grade, as well as for the Investigation Agent 5, or known as Supervising Agent katong sa mga field offices. No, there was no changes of their salary grade. Now for Investigation Agent 4, so there was no changes of their names as well as their salary grade from Investigation Agent 3 up to Special Investigator 3. So the lowest rank in the NBI is Special Investigator 3. Now let's go to with the FBI. The FBI was created probably as a single most major development in criminal investigations in the United States. Was the establishment of the FBI in 1924, originating as the Justice Department's Bureau of Investigations in 1907. The FBI originally had a very few responsibilities. When new federal laws governing interstate transportation of stolen automobiles were passed, However, the Bureau extended much disregards John Edgar Hoover's. Now, remember John Edgar Hoover, he was the first appointed director of the FBI when the FBI was created way back in 1924. Again, John Edgar Hoover was appointed as the first FBI director way back in 1924 when the Federal Bureau of Investigation Agency was created. That he would strive to eradicate corruptions and get the agency out of politics. Muna sa Amerika, pwede dakpon sa FBI o file kaso ang presidente o senador. Pero di sa Pilipinas, tistingig dakop bisang ang atong FBI director dili basta-basta makadakop sa mga senador o congressman, no? Kay naamay balaod ta katong immunity, no? So while the Congress is on sessions. Okay, now let's go to the legal safeguards of persons under custodial investigations as mandated by Republic Act 7438. If an individual finds himself into a certain situations that resulting to his arrest, it is important for persons of authority such as the public officers to inform the arrested person about his or her rights. Now, even the Philippine constitutions give mandates to law enforcement agencies while in the conduct of custodial investigations under the Article 2, no? Article 1 and the Article 3 of Section 12 of the Philippine Constitutions, which is clearly mandated that every person who are under custodial investigations or arrests, the police must shall properly inform the basic rights of a persons under arrest or subject for custodial investigation. Any person subject for arrest must properly be informed of the offense that he or she committed. So, it was clearly also enforced under this law, the Republic Act 748, on what is the language stated by the Article 1 and the Article 3, Section 12 of the Philippine Constitutions was given in force by the Republic Act 7438, which is strictly mandating that a person who are under custodial investigations must be properly informed of his basic rights as part of the so-called due process of law. So what is the due process of law? There are two important events or features on the due process. First is the right to be informed and the right to be heard. So unsa man ang right to be informed? Kailangan makabalo siya nganong gidakop siya unsa iyang sala nga nabuhat. And then right to be heard. So dapat na sa tagaan sa katungod o panahon nga dunggon ang iyang mga rason o iyang pag-explika o pag-justify sa usa ka butang nga iyang nabuhat. Una siya pag-desisyonan nga guilty, no? So unproven wise. There are some cases when public officers violate the law. So although violating the rights of individual during the custodial investigations is not a new language, that is an old term. For those persons who does not have any idea about these constitutional rights, unlawful arrest may seem normal. So mo lang uban, if you try to look at the warrant of arrest during the conduct of arrest, the police officers, that is optional for them to bring the copy of the warrant of arrest, provided that when they conduct the persons who having an order of arrest from the legal authorities, they need to inform their authorities, no? They need to inform their authorities and they need to inform the basic rights of a persons during the time of arrest. Now, if the persons resist to arrest because the police officers failed to bring the warrant of arrest and then they forcibly bring the persons subject for arrest by the virtue of warrant of arrest, but the problem is hindi lang nadala yung warrant of arrest during the conduct of arrest, it doesn't mean that the said persons are illegally arrested. Pwede naman pagdating doon, ang importante lang napaalam yung kanyang karapatang pantao, nagpakilala yung pulis, nahuli doon sa suspect, and then pagdating doon sa police stations, kailangan ipakita mo talaga ang warrant of arrest. Kasi kung wala kang may pakitang warrant of arrest, yung paghuli nyo sa kanya at that time, that is considered as illegal arrest kasi wala nga kayong authority. If you're trying to say invite, but you're forcefully take that person. Kasi ang invite kasi, pag ayaw ng tao, huwag mo siyang pilitin. Kasi magkakaroon talaga ng legal technicalities dyan. Now, let's continue. The Republic Act number 7438, an act defining a certain rights of a person arrested, detained, or under custodial investigation, as well as the duties of the arresting officers or detaining investigating officers, and providing penalties for violations thereof, provides a comprehensive explanations about the rights of an arrested persons and the penalties for public officers who violate the law. So there are also some instances na yung mga suspect lang, yung mga person of interest na inimbita nung kapulisan tapos nagkaroon ng police lineup, they invoke their rights. Sabi nga sila, their rights is violated. Now, police lineup is not part of the investigations. No, that is only a matter or a process of possible identifications. So meaning, during the police lineup, the suspect cannot invoke their rights because there was no rights violated at that time. No? So walay violation sa police lineup. Not unless, imo silang i-investigahan, so that is the time you need to inform their basic rights. Okay? Under this act, any person is subject for arrest or under custodial investigation must be immediately informed to have his legal counsels to assist him during the conduct of tactical investigation or interrogations. Now, dito naman tayo sa right to have a legal counsel. Kasi sabi nga ng unang batas, you have a right to have a legal counsels of your own choice. But if you cannot afford to have one, the state to the police stations will provide you one without any single centavos expenses at your own side. So meaning, klaro kayong balaod, nag-iingon dito na ang tao nga gidako na ay katungod nga mukuha o mupili o usa ka abogado nga para iyahang gusto, no? Pero iyang bayaran. Pero kung wala say kabayad o mukuha o usa ka abogado, ang atong gobyerno pinagi sa atong kapulisan muhatag sa iya o usa ka abogado nga libre sa tanang mga galastuhon. Karon ang pangutana, wala man siya makuha ng abogado, wala siya private counsel at that time, and they have no capability to pay the expenses to have a private counsel. So, gitagaan siya abogado. Nya karon kay katong abogado nga gihatag siya dili man niya gusto, is the right of persons to have a legal counsel of his own choice violated? Legally, yes, but technically, no. Ano man? Legally, kay dili man niyang gipili, gihatag raman to sa iya. Karon, technically, there is no violations. Why? Because under the law, the police officers cannot conduct a question and answer during the custodial investigations if the suspects are not assisted by a counsel either by choice or by appointment. Okay, so klaro kayo, no? So klaro kayo. Kung maabot ang abogado dito, mingon ang suspect nga, dili ko gusto sa imo ha. No, dili ko gusto gobyerno nga abogado. So, wa man siya partay kabayad. So, ang abogado ana, ingnon siya sa abogado. Yes, tinuod, dili ko nimo gusto. Ug wala ko na ako gigusto nga mahimo nimo abogado. Apan trabaho na ako ang moabogar kanimo pagabantayan ang imong tawhanon katungod sa mga posibleng ipangutana karon kanimo base sa mga pasangil nga gilabay ngadto kanimo. So mora na ang trabaho gid sa legal counsel, bantayan ang iyang katungod, magaprotektahan siya o pagadipinsahan kung unsa man ang mga pangutana nga dili angay pagatubagon sa suspect. Okay? The law clearly mandate to any public officers and or employee of anyone acting his order or his place who legally arrest or detain or investigate any persons who is allegedly committed a crime shall be informed of his right by way of using a clear language. So, unsa man yung clear language? Klaro kani under the rules of court, no? Under the rule 113, no? Dito sa arrest. The police should use a clear language. Unsa man yung clear language? Katong mga lingwahe or pinulungan nga madali lang masabtan sa usa ka suspect sa kaso. Kung dili siya kasabot sa language nga Tagalog, so iya ginang Bisayaon. No? Kung foreigner po na siya, so kung dili po maka-istorya, makalahutay istorya ang pulis, magkuha po interpreter ang pulis. So para dili ma-violate itong ginatawag nato nga use of a clear language or a dialect that persons under investigations can easily such as to remain silent and to have a counsel by his own choice. If the arrested person cannot afford one, the state will provide one through the initiative of the police officers who handle the case. So, under the Section 2, Paragraph B of the Rule 113. Okay. The enabling clearly stating that assigned investigator in case that the investigation report must be made into writing and it must be signed or thumb mark. So, mana na tayo ginatawag karon na Q&A nga form, no? And then pag Q&A nga form na, dapat ang tubag dito, sulat gina sa ballpen, no? Ang mansara na katong suspect na gi-imbestigahan para iwas pusoy. By the person arrested or detained who do not know how to read and write, it shall be read and carefully explained to persons under investigation by a counsel who assisted to be provided by the assigned investigator in case in a language or a dialect known to the persons under investigations. Otherwise, the investigations are considered as null and void and no effect. So kung magamit kag foreign language, ang kasabot ng tao nga imong gibistigahan, so which means na ikaw lang ang nagbuot-buot ato, when in fact, nagpirma-pirma na lang ang akusado ato bisag wa sa kasabot kay imo man siguro siyang kuan ngani pirma na lang kani mo na imong pangutana sa ko dili day mo ang unod sa Q&A or sa undertaking or sa affidavit. Okay, so that is tantamount to the violation of the rights of a person, the right to be informed. Any extrajudicial confessions made by a person arrested or under custodial investigation shall be made in writing and must be signed by said persons with the presence of counsel. So klaro kayo, any extrajudicial confessions or whatever the informations made by the suspected persons who are under arrest and under custodial investigations, all of this must be signed in the presence of his counsel, either by choice or by appointment. Kung wala gani siya abogado during sa custodial investigation o katong paghatag niyang information ngadto sa atong kapulisan na ang iyang isa ka basic rights na katong magtagaan og usa ka abogado o pag-asistihan sa usa ka abogado sa adlaw nga pagpangutan o pag-imbestigar kaniya, kung walay abogado, ang tanang mga gihatag nga informasyon or ebidensya kana mahulog nga dili pagadawaton sa atong korte. Nga naman, kay kanang mga ebidensya or mga information nga gihatag sa usa ka suspected person sa dihang gipangutana siya o sa dihang giimbestigahan siya, tungod kay wa man siya abogado, so ang tanan nga gipanghatag sa usa ka suspected person during sa investigation, mabaliwala ang tanan. Just like in the case of, because that the concept was taken into the doctrine of Miranda. Not only the doctrine of Miranda, but also the doctrine of Scooby-Doo versus Illinois. Okay? So, dua ka klase is, ang una, in the case of Dr. Ernesto Miranda, and the second one is in the case of Mr. Scooby-Doo. Okay? Now, on the event, if a counsel is absent, a valid waiver in with the presence of a parent, elder, brother or sisters, spouses, the municipal mayor, the municipal judge, district school supervisor or priest or ministers of the gospels as chosen by him. So ngayon, kung wala siya abogado, di po siya gusto sa kanang abogado sa atong gobyerno. So, the police should make a waiver that the said suspect waive his right to have a legal counsel. But that waiver, it must be signed by the presence of the counsel or by the presence of his immediate family or their priest or pastor. Such extrajudicial confession shall be inadmissible as evidence in any proceeding. So kung wala ning mga gisgutan nga karakter diri, mayor, municipal judge, district school supervisor, priest or minister, or iyang asawa, or iyahang mga igsuon or ginikanan. So kung nisa nga, pero abogado, pwede na akong ginikanan nga magpamatuod nga nihatag ko sa inyong suho na ay waiver, and it must be signed in the presence of the counsel. So, mingkang, di mo sa kailang abogado, sir. So, kinalangga po ng abogado nga nagpamatuod po nga dili sa gusto ng abogado. So, para papirma dito sa waiver, ang witness dito mismo ang abogado. Alangay mo ng witness ang parents nga mudapig bang gina sa iyang anak, di ba? So, that is a simple idea, okay? The law clearly states that any persons who are arrested and detained or under custodial investigation shall be allowed to be visited or talks with his immediate member of the family, which shall include the spouse, fiancé. Sabi ng fiancé, kato ning iyang mga kauyaban, no? Parent or child, brother or sisters, grandfather or grandchild, uncle or aunt, nephew or niece, and guardians or ward. So ning ward, kato mga tao nga, ang ilang pagkatawag gibilin sa ilahan o katong gibilan sa iyaha, or any medical doctor or priest or religious minister chosen by him or by his counsel, or any national government organization duly accredited by the Office of the Human Rights. Na mao sa itong mabiolate sa Bureau of Correction sa BGMP atong una na gustong maistorya sa kuan sa pineriso ang iyang uyab tungang gabi na o bisag iyang ginikanan, mubalibad ang BGMP officer or ang correction personnel. Kaya dili na daw pwede o parang buntag kinal hayag daw kaya naman di oras sa visiting hours. No, that is tantamount to the violations under the RA 7438. Ang gingon diri, kung gikinahanglan gid pag-ayo na may istorya sa piniriso ang iyang gustong tao may istorya, dapat yun tawagan sa BGMP personnel or sa Bureau of Correction personnel katong taong gusto nilang maistorya kung gusto po ba silang makaistorya sa piniriso. So dili gina sa ingon nga dili na pwede kay kung nay nakadungog niya na ang iyang hangyo nga gusto niya maistorya ang taong gusto niya istoryahon nga wala sa gitugutan sa kuan kay paugmaan pa niya tapos naghikob na o nagwild, no? So pag-imbestiga na may bawaan karon, so katong duty officer of that day, so will be administratively liable. Even the senior officer, administratively liable po. Because klaro kay ang gisulti sa balaod. No? Ang pineriso, kung gusto niyang maistorya ang iyang tao, iyang ginikanan, igsuon, anak, apo, or whatever, basta nabutang diri sa balaod sa 7438, kana dapat pagatumanon sa atong mga hingtundan or authorities. Kaya kung dili, ma-charge ko sila og administrative. Okay? So, yan, no? As to mention of this act, custodial investigation shall include the practice of issuing an invitations. So, katong Wala kay warrant, talay nagsumbong dito, no? Kanang init pa kayo, katay, karong buntag na itabo niya, nagsumbong dahil dito. So, o nilampas ang 4 ka oras. So, imbitahan tong suspect. Pero kung nakay pagtugot, kung nakay pagtuo, nga kining tao nga inyong giimbita nga wala pay warrant of arrest, kaya ang purpose na para di siya katakas, karon inyo sang gidiretso og kulong. Violation ba siya? Under the terrorist doctrine, investigations and immediate custody of a person who are suspected of a crime is not a violation of rights under the terrorist law, no? Under the terrorist doctrine. So dili siya violation. Basta nalang gyud tao nga mo witness nga kana gid siya ang nakahimo sa krimen. Galing lang ay milapas na ang oras, mga 4 ka oras, 5 ka oras, so giimbitahan siya. So wala may warrant, di ba? Kay di man na kay kinalan kung daspat mang hot pursuit man gud ang pagdakop, no? Ana nasumbong din ang krimen. Nya karon kay nilapas na ang 4 ka oras, nya na konsensya tong witness, so siya ang nag-adto dito sa pulis. So para matagagustisya tong biktima o pamilya sa biktima. So gi-invite by means of invitations. So pag mag-invitation, pag magpangutana wala pa paulia ang suspect, itanggong na. Violation ba siya? That is kung siya illegal arrest as per se. So the answer is no, under the terrorist doctrine. Okay, under the terrorist doctrine. Okay. Arresting officers are reminded that once they fail to inform the constitutional rights of a person under investigations, detained or under custodial investigation, shall face and suffer a fine of 6,000 pesos or a penalty of imprisonment of not less than 8 years but not more than 10 years. So kung gi-violate sa pulis ang RA 7438, so mag-atubang siya og kaso, administrative and criminal. Administrative, pwede siya matanggal sa iyang pagkasaserbisyo or masuspended. Criminal, makulong sa 8 to 10 years o magbayad pag siya og multa na 6,000 for violations of the RA 7438, okay, for not observing of the said law, or both. And the worst is the assigned investigation case shall also face a penalty of perpetual absolute disqualification, shall also be imposed which have been previously convicted of a similar offense. So sa man kung mapayla pag siya ombudsman, na remember lahi biya ang kuan criminal case, administrative case, no? Pwede ba na sa separate? So yan. Now, RA 748, rights of the person under custodial investigation. Any arresting public officers or employee or any investigating officers who fails to inform any persons arrested, detained or under custodial investigation of his rights to remain silent and to have a competent and independent counsel, preferably of his own choice. And any person who obstructs, prevents, or prohibits any lawyer. So, mano na siya, katong dili nimo pabisitaho ng iyang abogado or iyang immediate family, no? Katong gisulti ka ganina, katong nga pwede mo bisita. Kung gikinahanglan gyud nga, may istorya sa usa ka piniriso. Of a person arrested, detained, or under custody or any medical doctor or priest religious message by his counsel, from visiting and conferring privately chosen by him or by any member of his immediate family with him, or from examining and treating him, or from ministering to his spiritual needs. Pasana mingon siya nga, sir, gusto na ko mistura mo, pastor sir, kay gusto ko mangumpisal sir. Yamingon ang police or ang jail officer or ang correction officer, di ba na pwede maugma, pwede man siguro ka mangumpisal, ugma na lang, no? Kay gabihin na kayo. So that is tantamount to the violations of RA 7438. Okay? Now, the salient features of Miranda versus Arizona, commonly known as a Miranda warning or Miranda doctrine. In a case of Miranda versus Arizona way back in 1966, the Supreme Court ruled that they detained criminal suspects prior to police questioning must be properly informed of their constitutional rights to an attorney and against a self-incrimination. So, this is the case which was adopted by our present law, the RA 7438. Even the Article 1 of the Philippine Constitution, Section 12 of the Article 3 of our Philippine Constitutions, in the case of Mr. Ernesto Miranda, way back in 1966. In the landmark Supreme Court's Miranda versus Arizona, the court held that if police do not inform the right of a person's DRS about certain constitutional rights, including their Fifth Amendment and rights against self-incrimination, then the confessions made may not be used as an evidence in court. So naapoy bala na naginasadaan sa constitutional rights amendments dito sa US Congress. The Supreme Court ruled that the detained criminal suspects prior to police questioning must be informed of their constitutional rights of attorney and against self-incriminations. The Supreme Court overturned Ernesto Miranda's convictions for kidnapping and rape because he had not been informed of his legal rights prior to confessing. So, actually, si Mr. Ernesto Miranda was convicted of a crime of rape and kidnapping in the lower court. But Mr. Ernesto Miranda filed an appeal to the Supreme Court, or to the Federal Supreme Court, and the Federal Supreme Court modified the decisions from guilty to not guilty by reasons of technicalities, because the rights of Mr. Ernesto Miranda during the time of arrest and during the time of the investigation, his right to have a counsels and right to have to remain silent was clearly violated at that time. Muna, pag-abot dito sa Federal Supreme Court, ang decision sa lower court gi-overturn sa Supreme Court kay naay pagpangabuso nga gibuhat ang kapulisan. So nasayang lang ang ago sa kapulisan, kay na-dismiss na guilty, not guilty si Ernesto Miranda kay tungod sa ilang sipyat. For example, Miranda did not know that they could ask for an attorney or remain silent during questioning. So meaning, atong pagdakop kay Miranda, wala sa gipaybalo sa iyang tawahanong katungod, ng abogado, o dili mo tubag sa mga pangutana, nga dili niya gustong tubagon, apan padayon gyapon ang pagkuha o pag-imbestiga kaniya. So sa diyang gipaylan nagkaso si Ernesto Miranda, so nakonbikto man siya sa trial court, nag-apila ang abogado ni Ernesto Miranda because believing that the right of his clients was tantamountly violated or clearly violated by the police during the conduct of investigation. Okay. For example, Miranda did not know that he could ask for an attorney to remain silent during questioning. The said rights are also called the Miranda warning, and they stem from the 1960 Supreme Court case, Miranda versus Arizona. During a 2-hour interrogation, Miranda confessed to the crimes. Lawyers would contend that Miranda had not been clearly informed of his rights to have a lawyer and against self-incriminations at that time of investigation. Thus, to protect these rights in the face of a widespread ignorance of the law, the court devised statement that the police are required to tell a defendant who is being detained and interrogated. These mandatory Miranda rights begin with the right to remain silent. Now remember, our constitutional rights will only start at the moment that we will be arrested. Now, our basic right will start at the moment that we will be arrested or investigated for a certain offenses. So, diya magsugod ang atong basic rights kung kitadakpon o pag-imbestigaan. And continue with the statement that anything said can and will be used against the defendant in a court of law. The police are further compelled to inform the suspect of his or her right to an attorney and allow for, if unnecessary, provide for. A defendant's attorney so can accompany him during interrogations. Kaya naman po good sa ato ang rules of court that all accused persons shall be assisted by a counsels in all any stages, no? Dito pa lang sa interrogations, pag-imbestiga pa lang kay Ernesto, wala na siya gitagaan sa iyang katungod nga makakuha og abogado or tagaan sa abogado nga mo assist sa iya during the investigations. And because of that, although he was convicted by the lower court, sa diyang giapila sa Supreme Court, ningon ang Supreme Court nga mali ang pagbuhat o pagdakop, illegal, kay ang rights ni Mr. Ernesto Miranda na violate, ug tungod niya na i-dismiss ang kaso due to the legal and technicality issues, no? So, legal and technicality issues of the law. So, na-violate sa Chicago man ata ni siya nga case, no? Okay. Because none of these rights was afforded to Ernesto Miranda and his confessions was thus unconstitutionally admitted at trial. So katong iyang gipangatag na yang mga gipagtubag ito sa mga pangutana tungod kay wala may abogado si Ernesto Miranda at that time. So katutan ang iyang gitubag sa mga pangutana o itanang iyang gipanghatag ngadto sa kapulisan during the interrogations, no, ang iyang extrajudicial confessions shall be considered null and void from the very beginning. Now, his conviction was reversed. Miranda was later retried and convicted without the admissions of his confessions. Okay, now let's go to the second case of Danny Scooby-Doo versus Illinois. So, ang kaso ni Scooby-Doo, dili kayo ta-familiarize aning. Ano man, kay sa tanan natong subjects sa investigations, even in other subjects, we always talk about the name of Mr. Ernesto Miranda, and we forget about what is the case of Scooby-Doo versus Illinois, which is similar to the case of Ernesto Miranda. Galing lang, nahulog lang si Ernesto Miranda ang sikat kay saya mang ginahitabo tong violations na right to remain silent, right to have a legal counsel. So kining kay Scooby-Doo, parehara ni sila og kaso ni Miranda. Galing lang si Miranda ni sikat kay siya man gid ang pinakauna nga kaso na ang tawhanong katungod na makabaton og abogado o dili motubag sa mga pangutana. Si Ernesto Miranda man ang unang naka-experience. O mao na ang first landmark case in the violations of a right to have a legal counsel. Okay. Mr. Scooby-Doo was arrested and was undergone custodial investigation for an alleged crime committed. While he was in the custody or detained, he was not given a chance to be informed of his right to remain silent. And Scooby-Doo's right to consult by his counsel by choice also deprived. So they have the same issues nearest to Miranda, no? Nor to be assisted by counsel during custodial investigation. Scooby-Doo's statements were later used against him and found guilty and convicted. So katong mga tubag sa mga pangutana nga gihatag kay Scooby-Doo, mo ito gihimong ebidensya kay isa man sa right. You have a right not to answer all the questions. If you answer all the questions, your answer will be used as an evidence against you. So mo ito ikatulo. So meaning, ang tanang mga gitubag ni Ernesto Miranda, nagpangutana siya sa pulis, sa diyang giimbestigahan siya, o ito'y gigamit ng ebidensya siya. Galing lang, tama ang gibuhat sa pulis, pero ang problema, nagkamali sila. Kaya wala nila gitagaan o abogado si Scooby-Doo, at the same time, ang iyang right to remain silent. When in fact, Scooby-Doo and Miranda have the same fate, and they have the same plight of their case, no? Scooby-Doo made a statement that were later used against him, resulting in him being found guilty. However, the conviction was upheld by the Illinois Supreme Court. The same gapon na konbikto si Scooby-Doo, no? Pero sa diyang ilang giapila sa Supreme Court, napildi ang kaso, overturn sa Supreme Court kay nakita nga naay violations. O ang violations, it is similar to the case of Mr. Ernesto Miranda. Now, the Supreme Court overturned the conviction in part because the rights of Scooby-Doo was clearly violated by the police at that time. The Scooby-Doo rule embraced that individuals have the right to have an attorney when an investigation goes beyond the general inquiry and focus on a particular suspect. So, mo to, klaro kay isulti nyo, dapat naging abogado, no? This principle states that statement by a targeted suspect who is in police custody is not admissible at trial. So, anong inadmissible man ang mga ebidensya o impormasyon nga nakuha kay Scooby-Doo tungod at the time, no, anang panahon na si Scooby-Doo wala siya gipaybalo sa iyang tawhanong katungod nga makuha og abogado nga iyang gusto or gitagaan siya og abogado para may mo-assist sa iya during the custodial investigation. So, nya wa pagigikuan pagpanayang right to remain silent, no? So, gipugos siya og pagpatubag sa pangutana. So, nahitabo, sayang lang, no? Gihapon, that is similar to the case of Miranda. Now, what is the role of law on legal principles applied in this case? So the legal principle applied once a suspect has been taken into police custody for the purposes of questioning. If the suspect asks for and is denied an attorney and the police have not provided the suspect with the proper Miranda warning, confessions procured from the interrogations made after the denial are inadmissible. So, klaro kayo. Kung nangutana ang suspect nga, pwede ba siya magpag-abogado tapos wala sa gitagaan and then gipangutana siya, so ang tanang mga tubag nga gihatag ngadto sa usa ka suspect sa kapulisan sa dihang nagkandak inig investigasyon dili pagadawaton nga ebidensya batok sa biktima. Okay? One day of January 30, Scooby-Doo was rearrested by the police and interrogated for the second time and informed about the statement of the other suspect who is under the custody of the police. The police and the prosecutor informed him, although he is not yet formally charged. He was detained, he was handcuffed, and he was interrogated for more than 14 hours. And his request to talk his counsel was denied. So katong sa kuan, sa RICB 48 na to. The lawyer Scooby went to police station and requested to talk his client, but the request of the counsel Scooby-Doo was also denied. Di ba ka, abogado na niya, gusto niya ang iyang kliyente, pero wag po siya gitugutan sa pulis. So, ang naitabo, dismiss ang kaso. Scooby-Doo was never informed of his right to remain silent and was later convicted of murder trial. Scooby-Doo appealed this conviction. The court held that once the process shifts from investigatory to accusatory, when it's focused on the accused and its purpose is so illicit, a confession, the adversary system begins to operate and the accused must be permitted to consult with his lawyer. Pero wala na siya dito man sa police, no? Itong Illinois police. No. The duties of the police during custodial investigation is very important tool because any police investigator assigned to conduct tactical interrogation or investigations have moral obligations to the persons under investigations, most particularly on the protections of rights of a persons under investigations. So the RA 743, it must be properly observed. Failure to observe it may cause damage to the future or career of the police officer. The arresting officer or the police investigator should strictly emphasize the Miranda doctrine while conducting a questions and answers in the investigation process. Now, going back with our previous discussions that if the police failed to observe the Miranda warning or the Miranda doctrine during the conduct of investigations, whatever the information or evidence taken from the subject under investigation cannot be used as evidence in court. Okay? The arresting officer or the investigator on case, as the case may be, shall ensure that a person arrested, detained, or under custodial investigation shall at all times be assisted of his or her legal counsel either by choice or by appointment. The arresting officer or the investigator in case, as the case may be, must inform the person arrested detained or under custodial investigations of the following rights under Miranda Doctrine in a language or a dialect known to and understood by him. So what is arrest? Arrest is the taking of persons into custody. What is the purpose of arrest? In order that he may be bound to answer for the commissions of offense. What is the procedure of arrest? How arrest is made? By an actual restraint of a person to be arrested. So, by submission to the custody of the persons making the arrest. Rules in making arrest. So, in the conduct of arrest, the police are prohibited to apply unnecessary force or to apply a third-degree force. Violence or necessary force shall not be used in making an arrest. Duty of arresting officers under the Section 3 of the Rules of Rule 1133 of the Rules of Court. Arrest the accused and deliver the accused to the nearest police stations or jail without unnecessary delay. Now, once the police arrest a person by the virtue of warrant or by a warrantless arrest, they are obliged to turn over the arrest to the nearest police stations. Failure to do so, they will be charged of arbitrary detentions. No? So what is the procedure and execution of the warrant under the Section 4? When should the warrant be executed? Within 10 days from its receipt. Now remember, once the warrant of arrest is issued, it must be served within 10 days. But remember, the lifespan of the warrant is the lifespan of the warrant is up to the last once it is served. No, meaning only the executions of the warrant of arrest will lapse, but the effectivity of the warrant, and that is a lifetime until the warrant of arrest shall be served to a person subject for arrest. Now, ang ka-diferensya sa warrant of arrest o sa search warrant, ang search warrant, it must be executed within a time frame of 10 days. But the lifespan of the warrant is only 10 days. No? Ang lifespan sa warrant, search warrant is only 10 days. Ang iyang execution within 10 days. So meaning, ang sa warrant of arrest, ang iyang executions or to be effect, no, within a time frame of 10 days. Pero ang lifespan sa warrant of arrest is forever until the warrant will be served. While in the search warrant, so 10 days siya i-execute, then 10 days lang pud kutob ang iyang lifespan. So meaning, kung imo ni siyang i-serve karon, then tapos wala ni mo nahuman ang search warrant, so you need to inform the proper court for the extensions of the search warrant. Okay. Now, search warrant is very well detailed. No? Kung unsa yung gisulti dito lang kutob ang pwedeng buhaton sa kapulisan nga mag-search. Like for instance, ang giingon sa search warrant, you are commanding to search an alleged contraband within the possessions of the Mr. So-and-so which is hide into the cabinet. So kaingon dito, sa gihide siya sa cabinet, so sa cabinet lang kakutob mag-search. Di ka pwede mag-search sa tibuok balay. Okay, so stricto kayo ang search warrant. While ang warrant of arrest, it can be served anywhere in the Philippines. No, anytime, any day. While the search warrant, kung iingon dito, you are commanded to search during daytime. So meaning, during daytime lang ka, buntag lang ka hangtod alas 5 minutes na pay adlaw. Pero kung mag-search ka gabi o kadlawon, so dili na siya makonsidered, and that is what? So illegal arrest ang mahitabo, no? Who shall cause the executions of the warrant of arrest? The head of the office to whom the warrant of arrest was delivered. Duty of the officer assigned to execute the warrant. Within 10 days after the expiration of the period of the officers to whom it was assigned for the execution shall make a report to the judge who issued the warrant. So like for instance, when the police officer served the warrant, but sad to say the person subject for arrest is nowhere to be found. So the warrant officer or the police who served the warrant should make remarks on the warrant of arrest. Like for instance, kaya wala man ang katong itakas man itong dakpunon, no? By the virtue of warrant. So butangan niya nag-remarks na person subject to be arrested is nowhere to be found. So automatic din nga kanang warrant, i-report niya na dito sa judge na nag-issue or sa korte, no? Citing the reason why the warrant was not effected. So para ang warrant, mahimo na siyang standing warrant. So meaning, wa man siya na-serve, it doesn't mean na wala na effective, dili na mag-epekto ang warrant. So, epektibo ka po ng warrant once na ang person subject for arrest or the accused person subject for arrest will be located or traced, no? Pag maibawan na kung asa siya nagpuyo o asa siya nagbalin, asa siya nagtago. So, anytime pwede na siyang i-request, no, with the same court or with the same branch of the court who issued the warrant of arrest. So unlike sa search warrant, pag i-issue ni siya karon, imo ni siyang giserve karon, so dili na siya pwede pang ikuan, no? Pasana karon nga imo siyang giserve karon. Ya karon wala nimo na human. Una ka kuan mo ka ugma lang magpadayon pero wala nimo gi-report sa korte na wala nimo na human karong adlaw. So tungod sa kadako sa area nga i-search. So dili na nimo to siya ibalik tong search warrant nga gi-issue sa imo karon. Kung imo ka putong balikon on the following day kay mo continue ka kay wala nimo na human. So meaning ang imong pagbuhat sa searching sa balik is illegal. So whatever the evidence taken from the said premises or building on the second day, so it can be considered as fruit of the poison tree na siya, no? So fruit of the poison tree na siya. Kaya nga naman, wala man nimo siya naman kagahapon pero wala ka nagpahibalo sa korte na wala nimo naman i-continue nila mo karon. So para katong warrant na gi-issue sa imo ha, validate, i-revalidate lang to siya sa korte. Okay? So, pero ang warrant of arrest, pag dili nimo madakpan ang tao kay nitakas, so imo lang ibutan to remarks na wala siya na ang tao nga dakpunon, wala na dito ni hawa na, nowhere to be found. So katong warrant nga imong giuli dito sa court or sa court, branch of court nga nag-issue sa warrant, so nagapunto siya epekto, no? Pwede man to sa request pag mailan na or mabawa na kung asa nagtago ang tao nga dakpunon. Okay. Now, if warrant was executed, the officer executing the warrant should arrest the accused and deliver him to the nearest police stations or jail without unnecessary delay. So while executing the warrant, the police should not apply unnecessary force, or no violence or unnecessary force shall be used in making an arrest. The person arrested shall not be subject to a greater restraint than is necessary for his detention. So kinahanglan dili kay nato sa kanang kanang mga puwersa, no? So the police can only apply unnecessary force if there is a resistance to a person subject for arrest. So kung mag-resist ang tao, no, so di pa magamit og greater restraint ang police kay kinahanglan niya nga dalon na sa police station, no? So para sa atong gi-upload nga sa FB nga katong gipugos pag gipusasan sa pulis ang katong accused nga nay kaso sa korte nga gisug warrant na ginapugngan sa mga tao kay dili padala kay wala day warrant ang pulis. Now in the conduct of arrest, it is not necessary for the arresting officer to bring the warrant. The very important, they have a personal knowledge that the said person subject for arrest have a warrant of arrest issued by the court, no? So pwede nila lang dalon bisag wala sila nakadala sa warrant of arrest. Kaya pag-abot dito sa police station, so dito na lang ipakita ang warrant of arrest. Then tapos, basta ang importante lang, pag dakpo ni mong tao, kay nasa warrant of arrest, so para di siya makatakas, so ipaibalo ni mo ang imong authority na police ka, and then naka kay dakpon ang tao kay nasa warrant of arrest, gigisyo sa korte sa usa ka kaso. So kutob sa mong babag kung ilang pugnan ang pulis, so pwede silang i-charge of obstruction of justice, no? So pwede makasuhan tong tao nga gipugnan ang pulis, no? No, they compel the police, the arresting officer to effect the arrest or the warrant of arrest, no? Pwedeng pailan og kaso. Arrest may be made on any day and any time of the day or night. So, whereas ang search warrant, ato lang po i-compare search warrant, pag ingon dito sa search warrant na any time of the day, so, any time of the day lang dyan, kadili ka pwede mo buhat o search na hapon o gabi. Kaya gisulti sa search warrant is any time of the day, dili any time of the day and any time the day or night. Now, take note, kung mag-effect kang warrant of arrest, tapos pagkuhan sa tao nga dakpunon siya, nakita niyang pulis, gisiradaan niya karon ang pultahan. So, nabay katungod ang pulis na gubon ang pultahan. So, the answer is yes, no? Pwede lang gubon sa pulis ang pultahan para makasulod sila o i-effect ang warrant of arrest. Karon pagsulod nila sa balay, gisiradaan po ng balay, gikandaduan. So nakulong sila sa sulod. Pwede ba nilang gubon? Pwede gapon lang gubon. No? Because their life is now on the imminent danger. The same with the search warrant. Pag dili pa sudlon, gisiradaan ang pultahan, so pwede nilang gubon ang balay. And another issue is, pintay, wala ang tagtungod, wala ang tag-iya, katabang lang. So ang importante, ang katabang, kay bawon, no? Nga na'y warrant, okay? Or search warrant. So ang mas nindot yun, kung wala ang tagtungod, magdala o barangay officials ang pulis para iwas pusoy, no? Kay basig i-charge sila o trespass to dwelling or illegal search, no? Mas maigi lang na public official. In case of the failure to execute the warrant, he shall in his report state the reasons therefore. So itong sulti na ito ganun na. So kung wala na serve ang warrant of arrest kay ang tao nga dakpunon nitakas na nilayas, so isite lang niyang reason nga nung wala ni na-execute or na-effect ang warrant. If the arrest warrant is not served within 10 days, no, take note ha, pag ma-issue ang warrant, ang execution of the lifespan is 10 days, pero ang iyang effectivity is lifetime. Must the court issue an alias warrant in order to justify the arrest of an accused, no? So, wala man na serve, so gibalik sa korte, karon kay na ibawaan na nga nagtago siya sa kalugar, so anytime pwedeng i-request ang iyang standing warrant. No alias warrant of arrest is need to make the arrest. No, no alias warrant of arrest needed to make the arrest. So, buhay pa sabot, dili kinanglan nga optional kung dalon sa pulis ang warrant of arrest or dili. Ang importante, ipabalo nilang katungod o ang reason nga nandakpo nila ang tao. So, okay, Pag abot dito sa police station, dapat ipakita din nila ang warrant. So para dili sila ma-charge. No alias warrant of arrest need to meet arrest unless specifically provided in the warrant. The same remains enforceable until it is executed. So ngunit tusod din na to. Kung wala siya na-serve, kaya nitakas ang priso, it means the warrant of arrest remains enforceable until it is executed, recalled, or quashed. The 10-day period provided in the Rule 113 Section 4 is only a directive to the officer executing the warrant. So, but what is the language of the Section 4 Rule 113? Once this warrant of arrest issued, it must be served within a time frame of 10 days. So, mani ang interpretation sa Section 4 sa Rule 113. So, the warrant of arrest remains valid until arrest is effective. So, it means that the warrant of arrest have no prescriptions or the warrant is lifted. So, pwede lang ma-lifted ang warrant kung nadakpan na ang subject person or giribok sa issuing judge, no? Kung giribok siya, so di pa nadili na mag-effect ang warrant. Now, let's go to the salient features of case versus Fry. Case Fry versus US. Now, Fry versus US, this is the landmark case of the polygraph, no? So, kining Fry versus US way back in 1923. In 1923, in Fry versus United States District of Columbus, or District of Columbia, court excluded the scientific validity of the lie detector because the technology did not have substantial general acceptance at the time. The court give a guideline for determining the admissibility of scientific examinations. Just when the scientific principles or encounter crosses the line between the experimental and noticeable stages is difficult to define. So, ang buhay ko sa botany, because polygraph have no specific limitations, no? So, meaning, there are some countries that the resort of the polygraph as use as evidence is inadmissible. While the course will go a long way in admitting experimental testimony, assume or recognize scientific principle of discovery, the thing from which the assumption is made must be sufficiently established to have gained general acceptance in the particular field in which it belongs, no? Now, essentially, to apply the Fry standard, a court have to decide if the procedure, technique, or principle and questions were generally accepted by a meaningful amount of the relevant scientific community. Now take note, in the Philippine context, whatever the result of the polygraph cannot be used as evidence in court. But in other court in US, some of the court accepted the result of the polygraph examinations, no? Provided that they said examiners are undergone a series of questions, no, under the Dover case. This standard prevailed in the federal court in some states for many years. Mr. Fry was charged with and put on trial for murder. At this trial, Mr. Fry attempted to call an expert witness to testify that appellant had taken a systolic blood pressure deception test and to further testify as to the result of the test. So meaning nag-request si Fry of expert that he will be undergo a polygraph examinations. And when in fact the court accept, no, the petitions or the motions made by the group of Fry. But when Fry was undergone polygraph examination, it was found out that the result is negative. So therefore, Fry is not the one who made the said crimes, but the result of the polygraph examinations was accepted by the court but not used as part of the evidence in favor to Mr. Fry, no? So gidawat pero wala gigamit. So convicted gyapon si Fry. Okay. Ya, tapos ako giyatag sa mga bata. So di na ka magpuan, di na ka mag
Live?
di sa mga Google Meet. Kay kulangon ka sa orasan. So ikaw na siya, sila na lang ang mag-upload. So, now let's continue. After the lower court disallowed the appellant from introducing testimonial evidence relating to the result of deception test, appellant applied the following crime, appellant appealed his convictions. The discussions made by the court that although the deception test is issued on a scientific basis, just when scientific principles or discovery crosses the line, because the polygraph principle is not so clear because it is governed with the principles of the psychological principles, no? So the behaviors, the emotions, no? So yan. And demonstrable stage is difficult to define. The thing from which the deduction is made must be sufficiently established to gain general acceptance in the particular field in which it belongs to be admissible. In other words, the courts believe that without an established place in science, the test is still in the unclear jurisdictions between experimental science and demonstrative science, and therefore inadmissible in court. Now, what is the role of law? So why the polygraph cannot be accepted as an evidence in court? When a test such as systolic blood pressure's deception test has not gained a scientific recognition from psychological and physiological authorities, the expert testimony regarding the results of such test is inadmissible. So, ang ergo, under the rule of law, so systolic blood pressure deception test has not gained scientifically from psychological because ang psychological principle, it is based on emotions, no? Behaviors of a person. It's not talking about the behavior of the so-called physiological responses. Although the physiological responses will be based in our central nervous systems. Okay? So, kaya nagkaroon ng doubts yung korte na mayroon mo itong scientific explanations. It is supported by the scientific principles. So, doon kay dili ma-establish ang scientific principles, so some of the U.S. court did not allow the resort the polygraph as part of the evidence, no? Especially in our countries, labi na sa Pilipinas. Daghang kayong attempt na mugamit og resulta sa polygraph, just like in the case of Carpo versus Court of Appeals, Enrile versus Court of Appeals. So, UFC Food International Company, so gi-attempt po nila pero wala gyapon gidawat sa Philippine Court. Now let's go to the salient features of case of Dobert. Now take note, in the present day, if the case is in relations to the forensic science or forensic evidence, so all the cases must follow the Dobert case. Now, ano itong Dobert case? Sa Dobert case, una isa lang ang expert witness, so iagi pa siya daan og a battery of cross-examinations, counter, recross, redirect. So until the time that the said experts will be established that he have a full knowledge and he knows what he is doing. So, yagi pa siya og cross-examinations, recross-examination, direct examinations, redirect examinations, hangtod nga makumbinsi ang both parties nga ang polygraphist or ang expert nagid siya knowledge, no? Nakabalog siya unsay ang gibuhat, gyud siya pag-examine, so kinala makumbinsi niya ang korte nga ang iyang gibuhat is supported by scientific explanations. So that's why we are now using the Dober case. So all forensic evidence submitted in court, all the experts should undergo the principles of the Dober case. Okay? The file rule was reviewed by the U.S. Supreme Court in the Dobert case, in Dobert versus Merodone Pharmaceuticals Incorporated, with the reference numbers of the case 509 US 579 way back in 1993. The case was brought by two children born with birth defects that the claim were caused by the anti-Nisoya drug. The Dober standard provides a rule of evidence regarding the admissibility of expert witness testimony during the United States federal legal proceedings, and the rule of evidence, also known as the law of evidence, that covers the principles that governs the proof of facts in case. Dober contest is a hearing conducted before the judge where the validity and admissibility the admissibility of expert testimony is challenged by opposing counsel. The expert is obligatory to establish that his procedures and reasonings are scientifically valid and can be applied to the facts of the case. Ako tugisulti na ito ganina, no? So, the experts will undergo a series of questions, no? In order to establish, no, the credibility of the witness before he will testify in the trial. This case brought by two children born with birth defects that they claim were caused by anti-national drugs, which is known as the Vindictin. So, ang kining kaso, katuning nag-file og kaso ang family sa pharmaceutical, believing that nga ang claim manggod sa Vindictin nga wala siya side effects sa buntis, no? So sa diyang ginainom na si Vindictin sa inahan, no, as part of the maintenance. So, pag anak nila sa iyang kambal na ay defects, no? Birth defects, siguro ang ilong napikas, ang kamot na bali. So, moto nga ilang ipailag kaso ang pharmaceutical.